Under corporate law, a person may be granted a proxy to vote a corporation's voting stock held by someone else. But the grantor of a proxy can typically revoke the proxy unless the proxy holder has a sufficient interest in the corporation to make the proxy irrevocable. In Haft versus Haft, a Delaware court considered whether a proxy holder's position as a salaried employee of the corporation is an interest sufficient to make a proxy irrevocable. Herbert Haft was the founder and CEO of Dart Group Corporation. In 1993, Herbert transferred his majority share of Dart's voting stock to his son, Ronald Haft. In exchange, Ronald gave Herbert a promissory note secured by the transferred shares that granted Herbert a lifetime irrevocable proxy to vote the transferred shares. The stock certificates were held in trust by the Haft family lawyers. In 1995, Ronald sent Herbert a letter purporting to revoke the proxy. In response, Herbert attempted to rescind the transfer of the voting stock to Ronald, claiming that Ronald's purported revocation was a breach of the stock sales contract. Ronald filed suit in the Delaware Court of Chancery, seeking a declaration that his revocation of the proxy was valid. Under Delaware law, for a proxy to be irrevocable, the proxy holder must have an interest sufficient to support its irrevocability, such as a security interest in the underlying stock. Ronald claimed that Herbert didn't hold an interest sufficient to make the proxy irrevocable. Although the sales contract stated that the promissory note was secured by the transferred shares, Ronald claimed that the family lawyers held the voting stock certificates on Ronald's behalf, and therefore that no security interest was ever actually created on Herbert's behalf. Alternatively, Ronald argued that even if the proxy were irrevocable at the time of his revocation letter, it would be revocable once he paid off the promissory note. Accordingly, Ronald moved for summary judgment.